Some marriages end in divorce, but how do you handle the thousands of issues concerning the children, the property, the money? We'll talk about the details of divorce right now on The Law Works.
From West Virginia Public Broadcasting.
The Law Works is made possible by the generous support of the West Virginia State Bar, the Monongalia County Bar Association, and by a major grant from the West Virginia Bar Foundation, promoting public knowledge of the law in West Virginia. The West Virginia Bar Foundation, the philanthropic organization for West Virginia's legal profession and justice system.
Marriages are sometimes messy, but not nearly as messy as divorce. My guest is attorney J. Douglas Crane. Doug, welcome back. We're trying to figure out how many times you've been here, and I don't think I have that many fingers.
Thank you, Dan. Pleasure to be back. Thank you.
Well, I want to mention that you practice divorce law in your private practice of law, but you've also done a couple of other things over the years, which I think add cred, they call it now, credibility, and it's one of the reasons I bring you in here. You served as family law master in West Virginia in the very earliest days of that system.
Yeah, I was the first family law master for Mon and Preston County, 1986 through 1990.
Now that position has changed a little bit. It's a family law judge, but the functions are still pretty much the same.
Yeah, it's an elected position, yes.
And you also serve as a family law mediator.
Yes.
And a mediator in a family law case gets involved in the case. He's not a lawyer for either party, but he is an intermediary, a mediator that tries to resolve issues between the two sides in the divorce. And that's almost a black art and a skill that I have not developed over the years. You do it, and I think you do it well, which is why I asked you to come back again. We want to talk about the details of divorce, how to divide up the property, and in shorthand terms, how to divide up the children. Because sometimes that seems like exactly what we're doing is dividing up the kids.
Yes.
That's not the philosophy that we want, but that's the effect that it sometimes has. Let's talk about dividing property first.
Okay.
West Virginia is not a community property state. We are an equitable distribution state.
Yes.
What is community property?
Well, example, most people at community property is, I believe, state of California.
Mm-hmm.
And it means that from the date of marriage, 1/2 of whatever is divided between the parties. 1/2 of the total estate is divided.
And that means that if on the date of our marriage, the husband is worth $10 million,
The wife just became worth 5.
that's just automatic. Everything that I have, everything that you have goes into the pot, and we each own half of it.
That's correct. West Virginia is not that kind of state.
How do we do it in West Virginia?
We're called an equitable distribution state, which says that the presumption is that 1/2 of the net assets acquired during the marriage is going to be divided equally, 50-50. So that if prior to my marriage I had $100,000, and then during my marriage I acquired another $500,000 worth of assets, upon my divorce I would be dividing the 500, not the 600.
So what's yours is yours. What is yours before the marriage continues to be yours.
That would be your separate property unless you do some overt act to make it marital property. The example we generally see is people get married, and maybe it's a second marriage, and I had a home before I got married, and it's in my name alone. That'll stay that way unless I put my new wife on the deed. Now I've done an overt act to convert that separate property into marital property. Now she owns 1/2 of the net value.
Many times I have seen that happen. One of the parties comes in, they have a house that they got through a prior relationship
Or inherited.
it,
Yeah.
or in some cases may have built it while they were single and
Yes.
simply owned it. Then they come in and says, I want to put my husband or my wife on the deed to this property, and I generally say, we need to have a little talk, just you and I, and let's not bring your spouse in here yet about that. because there are consequences of doing that.
Right.
If you put them on, what happens when you put somebody on the deed?
They become vested in the ownership of that property. And so as the guy that now puts his new wife on the deed, he can't say that I built that and it's all mine, never put a dime into it. That now becomes marital property because of his overt act of converting a portion of his separate property into marital property.
You can gift to your spouse a house, a silver tea service, anything you want. If you put them on the deed, if you give them something, then it's theirs.
It's theirs.
Now, the silver tea service is a bit problematic because you have to prove that there was a gift there, and you don't usually get a receipt back from your husband or your wife when you give them some tangible personal property. But a house has a deed. It's recorded in the county clerk's office. It's obvious.
Yes.
What happens when the proud parents of this young marital couple say, we're going to give you a house?
If they're going to give the house goes to the couple, and if it's in both names, it's fine. That's a marital asset to the young couple.
But sure as shooting comes the divorce. Mom and Dad come in and say, no, we were giving it to Junior. We weren't giving it to that woman he married.
Yeah. That's a problem, and very, very, very few people do it correctly. If I'll call them the grandparents, want to make a gift to one of their children and not their new son or daughter-in-law, they need evidence by a note, if it's a property, a deed of trust. So I've been at this 38 years, I've seen it done properly twice.
Yeah, that's a bit complex. What typically happens is son and daughter, or son and daughter-in-law, or daughter and son-in-law get married, and they come back to mom and dad and they say, we'd like to build a house. The bank tells us we're okay, but we need to have $20,000 as a down payment. And mom and dad look at that and they're feeling a little flush and they're feeling a little proud, and they think there may be some grandchildren coming along and we want to get in good with the grandkids. We'll give you that $20,000 down payment. And that's a nice gesture. It's a wonderful thing to do. But when the divorce comes, invariably,
the grandparents say, that wasn't a gift. It was only to our son, not our daughter-in-law. We want that 20 off the top. And it's just not going to happen unless they have the proper documentation and can actually prove, note, deed of trust, documentation that it was that kind of a...
So if it's a loan to the couple, it can be a loan, and the couple, all they have to do is sign a promissory note. It's called a demand note. They said, we're not saying we're going to pay it back in 2015 or 2020. The way it's written is say, on demand. That is when the person who loaned the money says, I want the money, we're going to pay it back to you. And then in the belief that money will never be repaid because really it was a gift.
Yeah.
But if there's a divorce, then the parents come in and say, here's the promissory note for that money that we loaned. We want that money back. And they have a fighting chance then.
They have a shot at it.
A shot at it.
And at best, if it's $20,000, at least maybe they can get 10 of it back, because they're not going to get the 10 from their son. And they don't want that.
They would maybe forgive that.
Forgive that, but yeah.
But they can also have that as a secured loan by filing what is called a deed of trust. And in West Virginia, a deed of trust and a mortgage are the same thing. So you hear people talk about mortgages, and there are some details or differences in the details. We need to worry about that here. And then, I guess, they would have a claim against the house, and that would give them a little better chance of getting their money back from son and daughter-in-law or daughter and son-in-law.
Yes.
That usually doesn't happen.
I've seen it twice in 38 years that it was done that way.
Well, I've been doing it for 32 years, and I've never seen it happen. So the last 6 years, I might get to see it a couple of times. That's equitable distribution. Then says if it was yours before the marriage, or if it was a gift to you, or if you inherited it from your family, you get to keep it.
Correct.
Generally.
Generally.
But everything else that is acquired during the marriage belongs to the couple.
That's the marital estate. As I tell people, I don't care whose name it's in, it's marital. If it's, and I hear this a lot, my pension, no. If you acquired retirement benefits or pension during the length of your marriage, it belongs as a marital asset, and your spouse is entitled to one half of those things you've acquired.
I went to work every day. They deducted the pension from my paycheck. That woman never worked a day during the marriage. She never contributed any money to the bank account. I earned every penny. she's not entitled to any of that.
Well, and she should say thank you, because our Supreme Court says yes, she is. And she gets 1/2 of the pension during the time you were married.
I kind of sometimes am forced to explain this by saying it may not seem right, but it is the law.
It is the
and that's
law
what
of the
it
state of West Virginia.
Now,
yes.
there's a philosophy behind that.
Well, the counter to that is, yes, you went to work, and she stayed home. She washed your clothes. She fixed your meals. And I believe the case that our Supreme Court said that is equal to you going to work. Took care of the kids, cleaned the home. You see these things out there where someone will say, I've out and priced the homemaker services, and it cost me $150,000 a year to get someone to do if I on the open market. So yeah, she did not go out, maybe not brought actively money into the house, but she went and bought the groceries. She did, but anyway, the Supreme Court says she gets 50% of that asset.
Typically, in a happy marriage, the couple will stand there and talk about how valuable each of them is to the other in a happy marriage. Well, when it comes time for divorce, you don't get to take that back.
No.
if you really were supportive of each other, there is a value to that.
It's a true partnership, and partners work together, and the extent each one of them, the whole is better than the parts.
Back in the 1950s, at least, that's when I remember it happening. We used to laugh at the Soviet Union, the concept of marriage in the Soviet Union, because they just went down to the clerk of records and they registered the marriage, and that was all there was to it. There was no sacred ceremony about it. There was no church. There was no wedding dress. They just went down and said, we're going to be husband and wife now, and the commissar who ran the clerk's office said, thank you very much. Go and have children if that's what you want to do. But in the United States, marriage really is just that simple. We have things around it to signify the solemnity of the occasion. But when push comes to shove, a marriage is a business for the acquisition of property and the production of children. And when it comes time to dissolve that business, it's handled pretty much just like the dissolution of any other business.
Any other partnership.
If we're partners in a pet store
Yes.
or something else, you'll take the snakes and I'll take the rabbits, and we're going to divide this thing. Or you'll get half the snakes and I'll get half the rabbits. And it's probably best to look at a marriage like that. It takes some of the glow off of it, but if you see it as a business while you're in it, while you're conducting it, I think you're likely to come out further ahead.
Well, love is blind and sometimes expensive.
We got together before the show and we picked up a couple of forms that are used in divorce cases, one of which is a financial statement. Now, these forms vary a little bit from county to county. This is one that both Doug and I have used.
That's the Supreme Court one.
This is the Supreme Court
Financial statement.
required or recommended form, and each county changes them a little bit. But on the first page of it, it tells you what documents, if you're getting divorced, you need to produce. You have to have access to, you have to review, typically with your attorney or maybe your accountant. And there's a pretty impressive list here.
Yes.
A copy of your most recent wage or salary stub showing gross pay, deductions for taxes and other items, and net pay for the normal pay period and for the year to date. Now, if you work for a big company, you get those kinds of statements as a matter of course. But if you work for me, you may get a substantially simpler document than that, but that's what the court requires you to get. Doug, why don't you take this and get down that list and talk about some of those other forms.
Yeah, the most recent pay stubs, your gross, because now child support is based on gross income, not net income. You need your tax returns for the last 2 years.
Now, tax returns are sometimes tricky to get, because many times I've heard people say, well, I don't have anything to do with that. My wife takes care of the taxes or the finances, or my husband takes care of the taxes and finances. It's a business. You need to have some involvement in that. The IRS presumes, for example, if you sign a tax return, you read it and you understood it and you know what's in it.
And if there's liability, it is a joint liability, even though the one spouse may not have put a penny in the W-2s or the 1099s in there. If it's signed jointly, and the lien comes out, it's against both husband and wife. Period.
So both of you need to know where those tax returns are. You know, it sounds kind of harsh to say it, but everybody should have their own filing cabinet, I suppose. Nobody ever does that.
No.
But in a perfect world, each of you would get a copy of the tax return. You might have a rubber stamp that says his and hers on it or something. Nobody ever does that, but that would technically be the best way to do it.
Yeah, and that's the person who has employed and gets a paycheck
W-2.
every week to 2 weeks or whatever. Number three, for self-employed persons, that's a whole different ballgame because you're reporting your own income. If you have a business, there are deductions you may or may not take. And the court wants to see, as does your other spouse, want to see what the value of that business is, what deductions you're taking. If they're all, not that they're not legitimate, but there are things that may be imputed or attributed back to a spouse. The example I can see is that a company pays for your car. And so they lease a car or buy a car for you, and you don't have to make a car payment. The court can attribute that income back in the figuring of child support. But these are why they need these information to be as complete and full disclosure, financial disclosure, as is possible.
And again, going back to the duration of the marriage, when everything seems to be going fine, I've had many people tell me, oh, well, my spouse reports $30,000 a year, but really she's working off the books and getting another $20,000 or $25,000 a year. And the next question is, did you know about that? Yes.
Yes.
Did you sign the tax returns saying that you earn $20,000 a year instead of $50,000? Yes. What happens when you go to court?
That's a problem. I mean, that's a real problem. And you participated in a fraud, knowingly and willingly, the other spouse. It's very hard to bootstrap yourself up again to say he or she's got money under the table.
Yeah, generally speaking, at the very least, you're going to be stuck with what you admitted to the IRS you were getting.
You filed under oath.
Yes.
I personally signed that this is my correct income. So don't do that.
I guess the advice there is don't break the law. It seems kind of obvious, but it is.
Yeah. Number four is very important for, there's cases that invoices showing any extraordinary medical expenses for the children, child care expenses, or special needs of the children. There are those cases where this is extremely important. People have children who have special needs or have illnesses, allergies, a lot of medical, and those need to be taken care of and put a special place for those in the child support formula so that the court can see where the funds are, what the absolute needs are for the children, not just daycare, but those things. And then when they try to do the child support formula, to make sure that they get, with the money available, an adequate child support.
We refer to child support formula, and we have this form here. Doug, basically what is this form, this financial statement, designed to do?
To give, and it's by the way, you can't fill it out once, but there is an ongoing duty for both sides to keep this updated and current, so that if your job changes or go up, go down, whatever, you inherit property, even though that may not be subject to equitable distribution. If I inherit $10,000 from my Uncle Joe, that's an asset. Now, my wife's not going to get half of that, but I can get interest off that. I can get so the court needs to know that.
So your income may go up.
My income may go up because Uncle Joe left me $10,000, and now I put that in a CD, and I'm getting 2 or 3% off of it. So yeah.
So this financial statement form is a picture of your financial situation at the time you fill it out.
And this must be done at filing.
At the beginning of the divorce.
Beginning of the case. So if a case takes 6, 8, 9, 10 months, obviously we're in a society that things change a lot. So just because I filed it on the first day that I filed the petition doesn't mean I don't have a duty to keep this current with the other side and with the court.
And typically at the final hearing or toward the end of the divorce process, somebody, the judge or the other lawyer, is going to ask you if your numbers here have changed.
Absolutely.
or should.
It should.
So that everybody knows. So the financial statement is a picture at the time of the beginning of the divorce, but as Doug says, it has to be updated. You have to keep it current during the course of the divorce, or at least advise everybody what has changed. But it also ties into the other form that we brought in here, which is the parenting plan.
Yes.
Because the numbers that are in the financial statement, at the very least, are used to determine what the child support is supposed to be. How does that work?
Well, child support is determined once we have a parenting plan. The court will determine, or by agreement, the parties will determine who is the primary residential parent.
Primary residential parent.
Yeah.
What does that mean?
It is the person with whom the children live with at least 50.111% of the time, just over 50%.
It's the person who gets custody of the kids.
Well, the word custody doesn't appear in our statute anymore. We have called parenting time, and that is the time that the children spend with each parent. There are those people who are fortunate that they can do an absolute joint custody, which means 182.5 overnights with me, 182.5 overnights with the other parent. That's out of 365 days. Most people can't do that, a true, what you would say, joint custody, where they actually have the kids 50% of the time during the year. But that's what child support determines. We have two types of child support, the basic child support and the extended child support, which allows for parents who have more than 35% of the overnights with them. And it's a sliding scale how child support changes.
Did the studio just start spinning?
I'm sorry.
This is, no, you're doing a fine job of explaining it. It is not simple.
No, it isn't.
Where are the kids going to be on Arbor Day? Where are they going to be on St. Swithin's Day?
Yeah. Well, this is what the parenting plan is supposed to do, so that you set up, when we set the parenting plan up, or the parenting plan was set up, it is based in, it assumes that every child's in school. So this has problems for 1 and 2 and 3-year-olds, but children eventually get in school, and so we have the regular schedule, which is basically September through May, and the summertime schedule, when they're not in school.
And
you set out the times that they were with each parent.
Once again, we have recommended forms of agreements and reports. This is a parenting plan that's used in some counties. This one from Monongalia County. Most counties have a similar form. This is a list of holidays that the parents are expected to divide up between themselves.
Right.
And they're going to say even years and odd years, who gets the children on each day, and it's major holidays like Easter and Mother's Day and Father's Day, things like that, Christmas, Thanksgiving, but it also includes Martin Luther King Day, spring break, Memorial Day, Independence Day, Labor Day, rather minor holidays when the kids might not be in school.
And compounding the problem is, not every school district is exactly the same. Some have a spring break, some have spring break that coincides with Easter, some don't. So while this is a general plan, it has to be your specific situation, what can apply to it. Not every school system takes off for deer season.
And not,
which is not in here, but
that's right. And not every spring break is as long as every other spring break. And sometimes, if the weather's been really bad, we don't have one at all.
That's exactly right.
We have mediators involved in family law, like Doug, who can take disagreements and help you work through them. You can do that, can't you?
Well, we try. And amazing, you will see people who sit down at a mediation, and you can tell, starting off, arms are locked, and things aren't going to go well. And after a few hours, there's a meeting of the minds. They finally realize that they're doing this for their children. I don't have to love you anymore, but we have children together, and now we've got to work this out. It's like a light goes off over and they work out a plan. My experience has been, and I think most attorneys that practice in family law, when a mother and a father have input into this parenting plan, and they've had some give and take, and I didn't like that, but I can live with that, and if you do this, I'll give you this if you give me that on Father's Day. The plan has a greater tendency to work.
If the parents don't successfully work out a parenting plan between themselves, who's going to decide where the kids go and when?
Family court judge where they are.
Family court judges are nice people, but they don't know you, and they don't care about you as an individual. They worry about your kids. You are the best person to make these decisions, but you have to make them cooperatively.
Yeah.
J. Douglas Crane, thanks, Doug, for coming back again.
My pleasure.
Thank you also for being with us. On behalf of the LawWorks, I'm Dan Ringer. Good evening. On the LawWorks webpage at thelawworks.org, you'll find a listing of recent The LawWorks show topics and additional information about this show's topic. If you would like to recommend this program to a friend, you'll find video of this program at thelawworks.org, and you can find previous programs on YouTube. If you would like to suggest a topic for a future The LawWorks show, or if you're a school teacher and would like to receive a copy of this program for classroom use, please send us an email to thelawworks@comcast.net.
The LawWorks is produced in cooperation with the West Virginia State Bar, the Mountain State Bar, and the West Virginia University College of Law. The LawWorks is made possible by the generous support of the West Virginia State Bar, the Monongalia County Bar Association, and by a major grant from the West Virginia Bar Foundation, promoting public knowledge of the law in West Virginia. The West Virginia Bar Foundation, the philanthropic organization for West Virginia's legal profession and justice system.
From West Virginia Public Broadcasting.